Bhanot for the better enjoyment of this session. Just make that request. Requesting everyone to be seated. Our distinguished panel, welcoming our distinguished panel to the stage. Namaskar and a good morning to all of you. On behalf of the Honorable Supreme Court of India, the Honorable High Court of Delhi, and the Delhi International Arbitration Center, I once again extend a very warm welcome to all our honorable judges, distinguished dignitaries, delegates, and invitees to the last day and the penultimate session of the second edition of the Delhi Arbitration Weekend. We have saved some of the best for the last, and those of you who have made the wise decision of spending your Sunday with us will not be disappointed. With that in mind, I would now introduce the topic for the day. Our topic for the present session is Keeping Up with the Tech, Exploring the Interplay of Technology and Arbitration. It is indeed a topical topic for the present times, and we have a distinguished panel to offer their valuable insights and useful tips on how to integrate and harness technology in arbitration practice and adjudication. With that, I welcome our distinguished panel. I firstly welcome our eminent chair for this session, Honorable Justice Aniruddha Bose, Judge, Supreme Court of India. Justice Aniruddha Bose graduated in Commerce from St. Xavier's College in Kolkata and obtained his LLB degree from Surendranath Law College. He started his legal career in 1985 and had a diverse practice focusing on constitutional, civil, and intellectual property law matters before the Honorable Calcutta High Court, handling cases both on the original and the appellate sides. In 2004, he was appointed as a permanent judge of the Honorable Calcutta High Court, and subsequently, he was appointed as a Chief Justice of the Honorable High Court of Jharkhand in August 2018. He was elevated as Judge of the Honorable Supreme Court of India on May 24, 2019. We are delighted to have Sir on the panel with us today. Now I turn to our distinguished panelists. We firstly welcome Honorable Justice Ajay Bhanot, Judge, Honorable High Court of Judicature at Allahabad. Justice Ajay Bhanot enrolled as an advocate in 1995 and had a prolific legal career at the Honorable Allahabad High Court, practicing civil, constitutional, tax, service, company, and criminal law. He was the counsel for the Government of India, standing counsel for the state of Uttar Pradesh, additional government advocate for the state of UP, and other organizations like Uttar Pradesh Public Service Commission at different points in time. He was appointed as an additional judge of the Honorable High Court of Allahabad in 2017 and took oath as a permanent judge of the Honorable High Court of Allahabad in 2019. Welcome, sir. I next welcome Mr. Gopal Subramanium, Senior Advocate. Mr. Subramanium commenced his legal practice in 1980 in the Honorable Supreme Court of India under the guidance of Mr. Soli Subrabji. In 1993, he was designated as a senior advocate, one of the youngest in the history of Honorable Supreme Court. His long and distinguished career includes being appointed as the Additional Solicitor General of India in 2005 and subsequently as the Solicitor General from 2009 to 2011. He received the National Law Day Award for Outstanding Jurist in 2009. He is an associate member of 3 Verulam buildings and a judge at the Qatar International Court and Dispute Resolution Center. Mr. Subramaniam has also been involved in several landmark cases which have shaped the legal discourse and jurisprudence on arbitration in India. Welcome, sir. I next welcome Mr. Richard Wilmot Smith, King's Counsel, 39 Essex Chambers. Mr. Richard Wilmot Smith was called to the bar in 1978. He's a specialist in all the aspects of construction and engineering litigation and arbitration and has had over 40 years' experience in that field. He has been in silk since 1994 and sits as an arbitrator and adjudicator worldwide in several high-value and high-stake cases. He's the editor of Wilmot Smith on Construction Contracts, 4th edition. His expertise also extends to issues involving European law, environmental law, including coal and nuclear power and waste incidents, health and safety, railways, and oil and gas. Welcome, sir. I next and lastly welcome Mr. Alberto Predieri, founding partner, the Bedin and Lee Studio Legale. Mr. Alberto Predieri was admitted to the bar in 1997 and to the Higher Magistrates Court in 2014. He's the founding partner of the Bedin and Lee Studio Legale. He specializes in commercial law contracts, advertising law, corporate law, including M&A transactions, inheritance law, and real estate law, fields in which he operates both during the negotiation phase and the litigation phase. Mr. Alberto has gained significant experience and expertise amongst others, in advising Italian and foreign clients in their investments in Italy. Welcome, sir. With that, I hand over the session to the chair to take it forward.
Thank you, and good morning to all of you. I feel a lot of comfort in the chair with such an eminent panel, which also means I'll have to do the least amount of talking. Well, the subject, the anchor person has already introduced the distinguished panel and panelists. I'm not repeating it. The subject for today is technology and arbitration. Well, arbitration, we all know. Technology possibly impacts arbitration at two levels. One is the external aid of technology. What you speak is being displayed on the screen. Immediately, the machine is transforming it from spoken words to written words. You can speak from remote. You need not be present in the arbitration hall. The tribunal itself, the members can be at different places, and it can be a true global arbitration, geographically speaking. The next level is using technology for preparation and, the more important, to write the award. Now, everywhere we hear about artificial intelligence, and we are placing a great reliance on it, and we are permitting to impact our thinking process as well. We put a problem on some key in the computer, and then the machine takes over. I think the machine looks at whatever there is in the web or on the web, on the subject. It prompts answers, and there's something in the machine which also decides which prompting to accept. That is at the preparation level. A lot of arbitration counsel are relying on this. The arbitrators, I am not yet aware who has relied on the machine understanding of the problem and made part of the award. Though I am told in some cases the award is being matched with the machine's version of what is right or wrong, and it goes into the thinking process of the arbitrator. Last week of edition of Economist, I was reading something about hallucinate. Apparently, I came to the word used in a different context for the first time. Otherwise, we undergo it or we do it all the time. Hallucinate is something the machine gives you a wrong answer. That is number one, one caveat for both for the preparer and the decider. I will put in a caveat. The second part is when the information which is before the large language models, now who is in charge of that information or who feeds it? We try to manipulate public thinking in different ways. We meaning collectively human beings, not the judges or the lawyers. We manipulate public thinking all the time. So I don't know, the experts will have to tell me or tell us if the large language model, the content there are exhaustive, so that it can pick up also inconvenient promptings as well. Now, this is one area we have to be definite, because this large language, ultimately, the entire knowledge bank, which forms part of the source of machine results, is made up by 8-10 corporations which have 8-10 individuals on the seat. I won't take further time. You have an eminent panel, and I'd request Justice Ajay Bhanot, my colleague from Allahabad High Court, just to give his version, whatever. And we'll entertain the reaction later on. We can sit and we'll entertain response at the end of all the four, or we'll make it interactive.
Justice Aniruddha Bose, esteemed panel members, sister and brother judges of the Delhi High Court, ladies and gentlemen. ADRs are becoming more of a necessity for the legal system than a mere option for the litigant. Technology is a transforming force, but it can also be a disruptive factor. The manner in which technologies were approached by societies since the advent of the Industrial Revolution holds lessons for us till date. One set of societies neglected technology. They faced disruption. The other set of societies adopted technologies, but could not adapt to the changes wrought by technology because they lacked institutions to help them adapt to the change. They too faced disruption. The third set was those societies, empires or nations which had the institutions to enable them to cope with the fruits of technology. The impact today, if we look at the past, as far as institutional and processes are concerned, will depend on how we structure institutions to imbibe technology. One thing that comes to mind from experience is that there has to be a dedicated vertical in every institution which deals with technology, where the personnel are equally adept at the domain knowledge and also well-versed in the technological discourse. The capacity building of users down the line in that institution has to be a continuous process to break down resistance to change. I'll give you an example. I was having some friends in a very large government institution. So they had purchased some gadgets and I had asked them, that's a lovely looking gadget. What do you do with that? So the friend of mine, he says, look, it's going to help us in video conferencing, digitization, and processing our documents. So at the end of 1.5 years, I met another friend in the same institution. His technology device had not been unboxed. And that was for the majority of the stakeholders in the institution. It was because the institution had not been structured. To the contrary, I was very delighted to meet some young lawyers in a law firm. I found that they had a technology vertical where a young lawyer was also doubling up as a technology expert. So that was very heartening to note. Then formalized structures of decision-making will always have an upper hand and will be better suited to deal with the benefits of technology and obviate its harmful effect. For example, the High Court arbitration centers will have a firmer footing on embracing technology than, say, ad hoc arbitrational processes. Of course, technology benefits are a given and need not be reiterated. They save time, cut down costs. Courts are recognizing them in a circumspect manner, as they should. We've accepted emails, contracts, judgments of the Supreme Court. WhatsApp as a mode of service has too received judicial recognition. Development of best practices in various related to technology in various arbitration centers, like the Singapore Arbitration Center, also shows the acceptability of technology. Various technical inputs like video conferencing, live transcription, document reviews, blockchain technologies to store data are being used. Record keeping is very important to the credibility of any adjudicative process, and considering the volumes of records which will be there, it is very important for us to embrace technology in that field. Similarly, digitization, like Allahabad High Court, on its part, it's done a very successful, huge digitization process of its legacy records. When we are talking about technology in these, if I may say, high-end conferences, we cannot neglect the segment of users of technology and the arbitral processes in our country. If I can define them, there would be 3 categories that come to mind. First is the international commercial litigation, governmental-based arbitration, and the third would be the common citizens. Now, this is where, when we look at the third category, that we have to acknowledge the existence of a digital device or a resource gap. It could lead to serious injustice if it is not acknowledged and addressed. But at the same time, we have to recognize that the same technology which creates a gap can also empower the persons on the lower end of the divide. Let me give you an example. In the state of UP, there are a lot of farmers who are taking loans from these finance companies. Largely whenever these contracts are entered into, they just walk in and literally stampeded through the loan processes by the very all dressed up company executives. Now, if an arbitration issue arises, there would be the typical issue of digital divide, but then they can be empowered. And I visualize a very fine young lawyer from anywhere in the country volunteering pro bono with all the technical gadgets at his disposal to help the farmer, or for that matter, it could be a case of an artisan in Varanasi or in Kashmir. Now, technology, how it is impacting, if we look at the 4 pillars of legitimacy of an adjudicative system, they are being challenged by technology. The first pillar of legitimacy is transparency on the one side, but you also have the concept of deep fakes, virtual reality, challenging this concept of transparency. Reasons. Now, reasons have been irretrievably embedded in our judicial system, reasons to support an order. If we look at AI, there was this halicin. This was a drug which was discovered by MIT, invented by MIT, using AI. So they had 62,000 molecular candidates in the library, out of which they picked up one. And that became a successful drug. It saved time, but it also had serious consequences. Excuse me. When they realized that the scientists couldn't come to the reason how the AI machine learning reached that conclusion. And if I can quote that humans remain, now this is a book, The Age of AI by Kissinger and Schmidt. Humans remain uncertain to this day how the programs achieved their goals. So that is about AI, the limitation that we see. The third is autonomy of the decision maker and the autonomy of the parties. That is also a pillar of legitimacy, which is again under serious threat, if I may say so. Again, an instance I'll give you, a judicial institution, which was in the throes of a transition to IT-oriented functioning. So the decision makers would typically pass an order, list this matter at the top of the cause list, or put up this matter at 2 p.m. So the computers, the IT vertical said, we do not have this option. Now, there were two responses in the system. The first thought process was, please go back to the old style of complying with ink-signed orders and produce and comply with the orders. The other, which persuaded more people, was that, look, there are some limitations, we have to live with those limitations. Now, that by and by started creating what is called an availability bias, that this is where your autonomy as a decision maker goes and no more. It was a classic case of human autonomy yielding to technological constraints. The fourth pillar is impartiality, which again you would be aware of biases which can strike or which can vitiate AI systems. The second challenge is a jurisprudential challenge, which is caused by technology. Our traditional understanding of legal and jurisprudential concepts based on geography, like place of residence, are being challenged. Execution of contracts is no longer physical. Even by emails, we are accepting contracts. Second, the pace of technology is such that it is altering our traditional neat balance of the legislature laying down passing a legislation, the executive implementing it, and the courts adjudicating it. The pace of technology is such that matters often reach the courts before the legislature is cognizant of that. So that power shift is something which the courts and our jurisprudence has to look at very seriously. Evolving of sound jurisprudential concepts reflecting these new realities is the task cut out for the legal fraternity. In conclusion, I would just say that institutions have to constantly evaluate the interface of technology and decision making. One has to be on the lookout what Anthony Kuhn used to call paradigm shifts in his book, The Nature of the Scientific Process. Decision makers will be judged not only by their ability to know the right answers, but also by the acuity to ask the right questions. Thank you.
Thank you, Justice Bhanot. Thank you, Justice Bhanot. You started with the possibility of being disrupted, but ended up with constructive aspects of technology only. We shall hear now Mr. Gopal Subramanium. He doesn't need any introduction, so I'll just ask Mr. Subramanium to give.
Could I sit here?
Yes, yes. I think all of us could sit here or go there, whichever is convenient.
Because it's meant to be an interactive session. So. Mr. Chairman, my colleagues on the panel, and distinguished judges, my friend the Attorney General for India. I'm going to quote 3 lines. I would not tell you from where I got it until the quotation is over. Additionally, AI-driven chatbots can handle routine client inquiries, freeing up time for lawyers to focus on more complex matters. With AI, lawyers can streamline processes, improve decision-making, and ultimately provide more effective representation to their clients. The quotation ends. This is the response of what is called Chat GPT to a question which I fed. Do you think we could have written this answer better? I don't think so. You ask a Chat GPT about the last 200 philosophers in the world and what was their philosophy, within seconds you would find that something is being typed on your screen. When you check the contents, you would say that even a doctoral student would take at least about 4 years to come somewhere so close to it. Now, that is something which is really important. The subject of technology and arbitration is now more important than ever. It is not simply the use of technology in the arbitral process with which we are concerned. We have all, because of the pandemic, we all have now become accustomed to technology. We use technology. Arbitral tribunals all over the world use technology, all institutional rules, whether it is the London court, whether it is the ICC, whether it is the Swiss, whether it is Singapore, whether it is India, everywhere. We all can use technology. And we do use documents to be stored in PDF formats, which can be annotated, which can be used. We now also have transcription services which can be undertaken through AI. Like, for instance, we have the Supreme Court transcribing many of the proceedings with the help of software. It is perfectly possible. The question which we have to really consider is the inroads which are being made by technology, particularly AI, in the legal profession, and I'm speaking today with reference to the arbitral world, is somewhat very demanding, and it needs to be very clearly understood. The first is, lawyers have to be advised about a matter being arbitrable. Second, they have to be advised about the possibilities of success. Third, do they have a good case? Fourth, who are the kind of arbitrators who would be able to understand a matter of this complexity and give a just award? Now, all these 4 questions have become very important for litigants in today's arbitration sector. They have become equally important for big law firms or lawyers or solicitors or whoever they are who are going to actually field and interact with these litigants or clients. And they are going to be asked all these 4 questions. What is happening in the real world today, and it's important to say that, is that many law firms are now acquiring what are called developed AI resources. Some of them are modifying it in-house for their requirements. But the fact is, ever since you had an IBM Ross out there, you have today AI resources which can be used as effective inputters for the purpose of giving you at least a rough outcome of what can happen. It is a reality. It is not something which is in the distant future. It is something which is of great importance, and all lawyers have to brace up to it, that it is almost knocking at your door. And if, in fact, you are going to come to some sort of a forecast on these 4 points in arbitration, then let us now take over and see what is that dividing line which is going to inform the mind of a distinguished senior lawyer like Mr. Banerjee here, or anyone, to say that I take this view and I can actually say, for these reasons, this is a more plausible view. What would be that basis? And how could that ever be empirically tested? And there one understands the limitations of predictability. The limitations of the human predictability are not as limited, they are better. That's why we're still human. The human intelligence does have a quotient which is of the unknown, which is more than what can be discerned through mathematical algorithmic prediction. But unless and until lawyers understand that what is being expected from them is something which is more important, more calibrated, more, shall we say, more exponential in terms of output, we all will start giving our spaces to technology. Which is why in many parts of the world, you have what are called smart contracts. What was spoken about as being hooked on to the blockchain. We have smart contracts, they determine actually even outcomes. So what do arbitrators do with technology? With the AI is another question. And there are many dangers also with AI, because depending upon the kind of coding which is given to the programs, the outcomes can be fashioned. A certain arbitrator or lawyer or firm or a litigant can be postured in the world of the internet in a certain way. And AI certainly cannot be used for the purpose of selecting arbitrators, although many law firms are, in fact, silently also using them to determine the profile of arbitrators and the kinds of awards they would render. Arbitrators should also be very cautious when they use AI. The temptation to outsource what is original work to be done by the individual has to be avoided. And AI offers a superb possibility for outsourcing. An essay which can be written by AI will be infinitely better than an essay written by us, overwriting words, scratching them out, rubbing them with an eraser. We have to understand that appearances can become reality. I therefore would urge all of us to consider the benefits. The benefits are fantastic. They shake you. When you see what an AI can do, you are not in your comfort zone. You may feel comfortable for the present, for the moment, but if you really are futuristic, you have to be concerned about what can happen to the contours of the legal community. I think I've said enough, Chair. Thank you.
Thank you, Mr. Subramanium. Well, you have allayed a lot of apprehensions I had expressed in my very brief introduction about arbitration. The question which is possibly emerging is whether human mind will review the outcome of artificial intelligence, or artificial intelligence shall review the outcome of human mind. list of speakers. See, I'll interject a bit. Our generation's interaction with something closest to artificial intelligence was in Pitman's shorthand, which was presented first time in 1837. And typewriter in commercial world came around 1870s. So which went on till 2007, 8, 9, 10. So I think Mr. Subramanium has explained a lot of things and raised more questions about others. So we have two more very eminent speakers, Mr. Richard Wilmot and Mr. Alberto Predieri. I'll ask Mr. Richard Wilmot to
Thank
take
you.
over.
Thank you very much. Distinguished panelists, Mr. Attorney, members of the audience, it's wonderful to see so many people here on a Sunday morning. When I first realized I was going to be speaking on Sunday morning, I had visions of an empty auditorium and thought everybody would be at home, but you're all here. Thank you. I'm going to switch a little bit away from AI. We've had two excellent talks about AI just now, and we also had a debate about AI yesterday afternoon. That was extremely interesting. But to me, I've always thought AI to be a little bit outside the comfort zone of my practical experience. And so I'm going to talk to you a little bit about practical experience, which I hope, picking up the remark about typewriters we had a minute ago, will bring us full circle. My professional life started in the era of the golf ball typewriter, the people dictating their pleadings. My pupil master, who eventually became an English Supreme Court judge, Lord Brown, dictated his pleadings. And I could recite them after 3 weeks with him because they were all the same, so many of them. That was 1978. Fast forward to 1988, I got my first computer. It was the state of the art. It was an IBM PS2 with a 1 megabyte hard disk, and I don't know what the RAM was, but it wasn't a lot, and WordPerfect. But they had things called macros, and I was taught fairly early on how to do a notice of appeal. The macro was COFA, and all the formal parts of the notice of appeal, which were either laboriously handwritten out or were dictated, were just out there immediately upon pressing the appropriate button. I'm now going to fast forward to my now experience as an arbitrator. The type of work, and it's important, the type of work that I do are major projects. Dams, oil refineries, hospitals, bridges, tunnels, and the like. Any major project has major numbers of people and technology and information, so that when the disputes come about, there is a huge amount of documentation. Go back to 1988, when I was, as a middle junior, I would be put in a vast room and about, say, half the size of this, and the walls would be surrounded with all the files, and I was told to get on with it. The amount of documentation then for a major project dwarfed the amount of documentation that we have now for major projects. So the essential thing for any arbitrator to do is to understand what the facts are, which brought about the dispute, so that you can begin to think about how it is to be resolved against the background noise of the parties squabbling and against the essence of the parties' pleadings. To do that, you have to understand where the facts are, and so many of them are digitalized. So you really are reliant upon technology. Now, I don't mean AI, I mean the simple technology of retrieval of existing facts rather than the deployment of new facts or the addition of new, I'll call it stuff, which comes from artificial intelligence. Let's just look at it in a mechanical way. Technology has transformed the retrieval of information. I sit on several cases now with on the Opus platform, where at enormous expense the parties have put all their documentation onto this vast database. You can be given hard drives which are terabytes, literally terabytes in quantity of information. And somehow you have to retrieve that information, and counsel has to retrieve that information. And it is a huge, huge challenge. We're told technology is good, and it is, but you have to be aware of the fact that it beckons you into huge highways and byways of volume. But in the end, you as arbitrator and you as counsel are limited by what's here. The information has to be able to be deployed in here and has to be gathered by counsel and put to you in a way that you can understand and retrieve. So you've got document retrieval, which is huge now. Finding the documents, ensuring, because part of what your role as arbitrator is inquisitorial. It's not wholly sitting back and finding out listening to what counsel is saying. Finding from the database relevant stuff. Seeing how, and putting a question to counsel to see how that works with the rest of the information so it can be integrated. Referencing it, and the like. One little thing which is wonderful now, the ability to rearrange emails into chronological order, all sorts of things like that. Because I hate, I don't know about you, but back when I started out, all correspondence was not first in time on top. The first document was on the bottom and you'd work your way up. Now with emails, it's like a full circle going back, but now with technology, it comes. But that's pretty mundane. But what it illustrates is that what most technology does is it transforms the mundane into the area where it's sensible and usable. For example, remote hearings. We've all had there's huge resistance, and has traditionally been huge resistance to the use of the telephone. In the 1980s, the idea of a telephone hearing was for a routine directions was almost heretical. Now we have in international arbitration all our hearings which, except the final one, and there are certain things to be said about the final one, are in fact done remotely. There are all sorts of challenges which arise from that in international arbitration because of time zones. But in the end, remote hearings, they didn't come in a banner of announcement. There weren't great conferences where we scratched our heads anxiously to see whether or not this was something to be applauded or feared. It just came. And that's what I found with most of the use of technology in my practice as a barrister and now in my practice as an arbitrator. Technology comes and is welcomed. Go back full circle. I'm going to stop now. take the COFA macro. That involved somebody showing me how to use my computer and how to get the best out of it, and how to save yourself half an hour of routine, how to save yourself planes, trains, and automobile journeys. But what I'm not talking about anything special or anything particularly difficult or anything outside what this audience sees every day. And what I worry about with the technology debate, the artificial intelligence debate, is that it is just one aspect. It's just the process of a continuum. We start with the typewriters, we go to my IBM PS2, we go to the Magnum document retrieval. AI is just one further step on. And one thing that I'm certain about is, and here I'm going to quote Donald Rumsfeld, my favorite philosopher, not David Hume. This is the known unknowns and the unknown unknowns. The known unknowns are that we know we've got AI, we know we've got technology, we know how we use technology at the moment, we know how it's transformed how we work. We know also that in the time of the golf ball typewriter, the number of lawyers and disputes was a fraction of what we have now. And yet, with all the time saving we've had and all the technology we've had, the amount of disputes, the amount of lawyers, well, I'm assuming that's a good thing, has increased. So I don't think we're going to have anything to fear from AI, provided we deal with it critically and appropriately. But it's the unknown unknown which artificial intelligence might bring about, because it is something which we don't understand. If anybody in this room thinks they understand artificial intelligence, I have to tell you you're wrong. If anybody says it, then you can contradict them, because the thing about artificial intelligence is that we are in the foothills. We do not know anything. And if we have the humility to realize that we don't know anything, then we might begin to understand what the challenges are. But as I say, technology, it's everyday progress. And suddenly we end up here talking about things which are unimaginable just a few years ago, but all deal with the same essential thing. The same essential thing is you as counsel or you as arbitrator have an enormous amount of factual information. You have to integrate that into something which is comprehensible, and you have to put it over to the arbitrator who must understand it. Those essential human things remain. Thank you.
Thank you, Mr. Wilmot. Another set of caveat. Does it something to do with the age band of the speakers? Or is it alertness, or rather alerting the youngsters about overwhelming dependence on artificial technology? I've always wondered if Rylands Fletcher case was to be referred to arbitration, could we have the same result? We now have Mr. Alberto Predieri. So far we remained with the common law countries in the panel. So maybe one
Thank you, Mr.
from the
Chairman.
civil law perspective. But I guess arbitration is the same in all forms of
Thank you, Mr. Chairman, Honorable Justice, fellows, panelist member, Attorney General, distinguished guests, and ladies and gentlemen. Speaking as the last after this stellar panelist is difficult, but then I realized that you have already listened from three very clever people, so I don't have anything to lose. And then I'm coming also from a civil law country. It gives me the advantage that I am speaking out of the box, so to speak. I'm the least qualified arbitrators among the panelists because my arbitration practice is very much focused on an industry. Although I am a commercial lawyer, I practice as an arbitrator in the sports sector, and even more in a specific niche within the International Paralympic Committee. Most of the cases I deal with, they involved a fairly big amount of emotion, which is something that I'm quite sure the artificial intelligence does not yet, at least, grab. But we leave it there, and then we see what we can say about it a bit later. Now, and I think that the question I asked myself when I was invited to this event is a really straightforward question. Can an AI be an arbitrator? And then I want to give you my perspective as a civil law lawyer, and from a country where we have European law that applies directly, and when we have a code of civil procedure that, although not expressly says that the arbitrator must be a natural person, it requires the arbitrators being a natural person. There are other countries in Europe, like France, Spain, and the Netherlands, where the rules specifically says that the arbitrator must be a natural person. So the answer to the question, can an AI be an arbitrator, should be already negative. Then I looked up in the European legislation, and again, there are rules, and probably you all know the General Data Protection Regulation, which is known as the GDPR, which requires certain caution and some provisions that forbid automatic decision when using data of subject. So again, it seems that an AI cannot take decision because it works somehow automatically. Then there is an upcoming piece of legislation which is called the AI Act, which is not yet into force. I think it would be approved at the end of April, beginning of May. But at least I went through the draft, which is the final one. And I can say for the first time, an official act within the European Union speaks about the artificial intelligence in the administration of justice. So it is something that is started to be seen as a possibility. But then it says something that at the moment it's very, very clear. AI system intended to assist. So again, the answer is, in my opinion, that AI cannot decide. So cannot be an arbitrator by itself, can assist judges, arbitrators, in their role. And even when an AI is used for that purpose, the AI Act requires a certain number of requirements so that the system is always monitored, supervised, and of course there is a really high degree of transparency. So everything has to be explained. We have to avoid the risk of the so-called black box, when we don't know what is inside. It is not only important to have a decision, but to understand how the decision has been taken. And that goes to also the requirement that we, in my country, we have, where the decision should be motivated. So you really need to understand. And at the moment, I don't think that that is what an AI can do. And again, I said that at the end of at the beginning, emotion is always there. When we act as a lawyer, when we act as an arbitrator, judges, there is emotion in every case. Now, especially in a civil law country where the decisions are not only taken based on precedent. In a system like mine, where the judge and of course the arbitrator, they have to take their decision in a specific moment, whether it is a geopolitical, economical situation, even emotional. I still don't understand how can an AI can grab all those elements and make the decision maker, whether there is a judge and arbitrator, comply by what the rules require in that specific system. So again, to answer and to the question whether the AI can be an arbitrator, I think at the moment, at least as this regulation stands, the answer should be negative. But of course, as it has been said, the AI can really help. It was like, acting as the role of a secretary of an arbitration board, support, research documents, maybe even write the award, but based on the direction of the arbitrators. And I think that can be the final answer and the final solution as the regulation stands. Then in the next, 5-10 years, maybe we'll be here again and we'll come to a different conclusion. Thank you.
Thank you, Mr. Predieri. We have some legislative lead about the reach of artificial intelligence in the process of arbitration from Italy. So that's one step forward and some contribution of the civil law countries which possibly we can adopt. Now, shall we panelists give some views after all of us have spoken?
I think so. I think we can say a few words,
yes.
each one of us, because we've all heard each other.
Yes.
If I could...
yes, Mr. Subramanium.
I think it's a very wide range which has been covered. All of us want to preserve human autonomy and control and the ability to judge, argue, craft, create. All of this belongs to the human sphere. And we as lawyers, as arbitrators, as judges, every one of us, we want to preserve this. And the point which I think Richard made with great eloquence about the ability to retrieve relevant information. And I think the subtext was that you are then able to really identify the core issues which arise in a case rather than simply wandering all over the maze. I think that's actually a very important point. We take it for granted. We really take it for granted. But technology has enabled that to happen. That is definitely a very valid point. The point which Justice Bhanot made about artificial intelligence being used for drug or molecular selection, it's quite true. In current day world, for candidates for new molecules, artificial intelligence is very important because it cuts many possible candidates very quickly once you feed in the algorithm about the various side effects and so on with reference to them. We also now have very advanced levels of MRI, which tell you not only about whether a person is speaking the truth or not, but can even make predictions about possible brain behavior in future. So there is tremendous advance which is being undertaken by technology. Definitely, we have to be keeping pace with technology, but at the same time, what my friend spoke from Italy, that emotion is something which AI bot or is not likely to have. That is impossible. Although I think it all depends upon the genius of coding programmers, because they might be able to even use some methods to get there. The point which I think we need to look at also is, where does the human triumph? How does he assert a certain degree of volition over the final outcome? I think that is what is engaging my mind. How is it that as lawyers, as judges, we are going to take responsibility for the final outcome? And that is where our responsibility lies. Thank you.
Mr. Wilmot, would you like to sum up the panel's views
Well,
in a way?
Yes, we've concentrated a lot on artificial intelligence. I think what's interesting is the elephants in the room are unrecognizable because we don't know where they are and what they look like yet. There is this innate fear we have that AI will remove our autonomy. And that's a possibility if we let it, but I think we're some years away from that in terms of where we are in practical terms, practical everyday terms about how it's going to be used. That's the way I see it, is I see it as a continuum from where we were, the quill, to where we are going to be. And the artificial intelligence is purely one manifestation of the enormous amounts of data that we've got. Much more data than we ever had when litigants began in the courts in England. The bundles would be about an inch thick. Now they are many, many volumes. They fill many, many rooms and many, many terabytes. It's the integration of it all. But in the end, it's the decision maker who makes the decision, as just been pointed out. I can't at the moment see how we're going to lose control of that unless you allow it to be. And the final thing that relates to AI, it relates to everything. It's as if there is somehow an objective answer to any particular case. Of course, there is never an objective answer to a particular case. There's always the human input, the input of emotion, for example, particularly in the sports, but even in major projects that I'm involved in, the emotion comes about very often through the personality of the project managers on behalf of the contractor and on behalf of the employer, that they butt horns and sometimes once the project managers change, so does the nature of the project disputes will change. So in international arbitration, finally, it's going to be led, I think, by the law firms, because they're the ones who are really at the coalface, that understand what's on the market and know how to apply it. Arbitrators like me at once remove purely the consumers, if you like, of what they give us. And the selection of arbitrators, there are all sorts of programs now which permit selection of arbitrators, but I suspect that's really pie in the sky in terms of a true understanding of the nature of the arbitrator that you want, any more than a prime minister can pick his cabinet using AI. He's not going to do that. He's going to work with people that he knows, or with people who know the people he knows. There's one particular aspect where our AI is going to take over, and that's in small disputes arising from internet. eBay does it at the moment. That virtually all eBay disputes are resolved very swiftly by the use of artificial intelligence. Those are incredibly low value, but also they don't involve the huge implications which most litigation has. One-off, small claims. They are already being dealt with by artificial intelligence, and nobody really notices.
Well, one additional comment. When I said emotion, I'm not aware what the situation is, but back in the 70s, there was the IBM working on a project of, I can't remember the precise name, but it was emotional mouse. Using a mouse that could detect the pulse, the sweating, we're thinking to arrive in, to understand what was the emotion of the user at that very moment. Maybe we'll ended up wearing robes that can detect our heartbeat, our swelling. Who knows? In the future to come, that could really happen. But there is also one thing that I think that the artificial intelligence is still really far away. Yesterday we had a really nice conversation about a completely different subject on the terrace, you remember? The conversation that we had is something that you bring home. It's part of your, it becomes part of who you are. The perception that you have of a social context, of an economic context, geopolitical, and that makes you, in my opinion, a better judge at the moment when you have to take the decision. If we look at the artificial intelligence, I can see, at least at the moment, something that looks only in the past. Because if an artificial intelligence looks at the previous decision, it's something that is not today, at least is yesterday. And so how can artificial intelligence grab the feeling, the conversation that we had in a completely unrelated situation?
Can I just come in here? This is a demonstration of the use of technology. IBM and the emotional mouse caused me to open my mobile phone, not being rude, go onto Google and look at the IBM mouse. And it's enabled me to retrieve an article from the Irish Times. IBM's latest mouse can understand mood swings through its special senses, 6 emotional states: anger, fear, sadness, disgust. And that is an article on the 28th of April 2000, 24 years ago. I think it makes your point, doesn't it, Alberto?
We'll hear from the audience, except Justice Bhanot.
Just make one. See, what I wanted to say was that technology and AI in particular has a subtle impact. It takes away human autonomy in a subtle manner, and we seed it in an unknowing fashion. Now, when I was talking about the halicin, the drug which was discovered, the problem with the technology makers was they did not understand quite how the AI system that they had generated came to that conclusion. Now, in technology interface with court proceedings, it is not directly out of arbitration proceedings, but out of court. I can relate an incident to all of you. How technology can subtly influence us and a wrong becomes a routine course of conduct. So this is from bail jurisdictions. I was sitting there at Allahabad, and typically we have a huge number of cases with us. So matters are called out, and a lot of times you find the lawyers are not coming up. So say it's serial number 92, the lawyer doesn't come up, and you move on to the next. Till one day, I started asking them to tell me the date on which the applicant went to jail. So it came to light that the serial number 92, the applicant had been in jail for 8 years, and he had lost contact with the lawyers. As far as our listing system was concerned, so I asked our registry, I said, you should be printing in jail since at the top of the cause list, because that's what shocks a judge first. Now the answer came, of course we all have a bureaucracy. The answer was that our program is not suited to do this. So that's where a subtly, we are yielding our autonomy. And then I said, all right, then I'll have to pass a judicial order. And suddenly technology started making sense of that order, and in jail, the time period of incarceration started getting printed, because we were finding, and I still find, that a lot of prisoners are in jail, abandoned by families or financially destitute. Lawyers are not reaching out to them. So that's where if you see in jail since, you ask for the status report from the courts, appoint an amicus, and hear the bail applications. So this is not strictly relating to arbitration, but certainly in adjudicating proceedings. I don't know, somewhere a similar template could happen in arbitration as well.
Thank you, Justice Bhanot. Any of you? I think first we shall look at the questions which, if some speakers want to say that, yes, AI is, equivalent to human beings in terms of thinking, then something in that line, we'll invite questions at the first. Then, of course, I'm not imposing it on the speakers or the audience. You are the speakers now. Okay. We are the audience.
Good morning, everyone. So my question for the panelists...
If you just briefly introduce you, Ish.
Yes, sir. I am Nishtha Jain. I work at Chambers of Shashank Garg. I've been in the profession since 3 years now. It was a lovely discussion that we had on AI. And we did discuss the advantages and disadvantages of AI in arbitration. My question is that there is currently no legislation that addresses the use of technology or AI in arbitration. So do the panelists think that there is a need to formulate the legislation?
There are legislations indirectly. The IT Act itself, then in the Evidence Act, then it can come by way of expert evidence, but it is for the legislature to come forward with a comprehensive legislation
I think it's a very good question because all over the world, there does not seem to be any defining breakthrough in studies to come to a conclusion how good or how bad it is. And the reason is that, fortunately, it seems common ground that human autonomy and human responsibility is still holding the field. It is still. Empirical studies about de facto diminution of human autonomy have not really been undertaken in the way in which they could be to assess at a later point of time. I think for all human beings to keep and retain control over the ultimate decision, instead of passing the responsibility to the machine or any other source, I think as long as that works, the chances of any studies coming through clearly are less than likely. I think until you have determinate studies, I don't think legislators of any jurisdiction would like to step in quickly. Because even in relation to things like social media, legislatures are slow because of the fact that there is still some human autonomy which is visible. Thank you.
My name is Atul Batra. I practice in the Delhi High Court and the Honorable Supreme Court, and also an independent arbitrator as well as arbitrator with DIAC. My question really is to Mr. Gopal Subramanium. But before I ask the question, Richard Wilmot mentioned about finding from the database, document retrieval. And Justice Bhanot mentioned about asking the right question. Then you also mentioned about selecting from the database of arbitrators as to which is the suitable arbitrator. Then from the counsel's point of view, what are the chances of winning, losing, and outcome of a judgment? The law being dynamic, changing, as Alberto had also mentioned, we can't predict what happened yesterday is going to be relevant today. So, and Justice Bose also mentioned whether humans will sit over outcome of AI or AI will sit over outcome of humans. But having made this base, my question is, when an advocate prepares a case or a judgment is delivered in an arbitration or a court annexed court judgment, how do you explain AI versus the dissent? How do you explain an advocate's opinion as a plaintiff's counsel or the claimant's counsel and the respondent's or the defendant's counsel? So that's how will the AI be beneficial, or how will it explain?
The AI has actually no posture at all. It has no name. It depends upon who uses the AI. So if a plaintiff's lawyer uses the AI and then appropriates the final product to himself, it is still his opinion, or it is still his point. Likewise, a defendant's lawyer can do it. Now you have actually, like Harvey, you have so many evolved legal tools which are available to many law firms all over the world for the purpose of accessing the database, whether it's judgments, whether it's about propositions of law. It does facilitate, shall we say, in the matter of retrieval and as far as time is concerned. I don't think we can ever deny that or dispute that. I think Metabase is very useful for that purpose. The more important question, which I'm urging you to consider, is at what point of time does responsibility begin? And at what point of time does it get fully consummated? And this is important because whether it is a lawyer or whether it is a judge or whether it is a law clerk or whether it is an intern or a junior, the ability to access and to be able to produce something is much sharper now. And therefore, we have to be more deliberative. In other words, the way I would like to possibly leave that as a thought with all of you is, if we can admit to ourselves that our zones of fallibility are much higher, if we are prepared to cede to ourselves that we can seriously err as human beings, even having the best material in front of us, even in terms of cognition. I think that may be a good start, because if you are conscious that there can be error, then I think it's an excellent vantage point from where you can assess and reflect.
Thank you, Mr. Subramaniam. We have time for 2 more questions. We panelists have taken disproportionate time compared to the number of people in the audience, but we have to go by time. So 2 more questions we can take.
Sir.
And we'd prefer from youngsters.
Sir, thank you so much, sir. It has been an interesting panel discussion. I'm Nitya Bansal. I am working, I primarily was an advocate, but I am moved to digitizing arbitration. So I have a platform which basically digitizes arbitrations. Now, yesterday also we had a debate on AI and how, whether it can mean less number of arbitrators and all. And I think today's points were very relevant because all the panelists have more or less agreed that we need to exercise caution while employing AI. At the same time, we admit that, it has its advantages. Now, having said that, I think we also agree that AI is also fallible. So it's not saying that, AI is infallible. So my question is, if we were to pin responsibility, if in an arbitration, say, the parties and the arbitrators together agree to use an AI software, maybe for transcription, maybe for predictive analysis, then who should, if there's a fault on, the AI's part, who should be responsible or accountable for a fault that happens because of the AI software or because of the data or the bias in the data or anything? So
I think the parties themselves can allocate the fault.
So I believe this should be the first step. Before employing any AI, I think there should be a disclosure that an AI software is being employed and who will be, whether it will be the arbitrator who's signing and agreeing or the parties who are proposing the use of the...
Most of the common AI programs, they carry that caveat that we may go wrong. It's there already.
I think there was a little, if I'm right, the question is, if suppose you have transcribing services, which often the Singapore Arbitration Center, many of them, they engage, then there is somebody who is in control, who is capable of taking responsibility for the transcription and what comes in. But I must say that it's one thing to transcribe, but as far as predictive analysis is concerned, that is something which cannot be permitted because that is the function of the arbitrator. So there must be a human face which is responsible.
Okay.
Yeah, my name is Sushil Shankar, and Mr. Wilmot Smith spoke about a continuum from the typewriter to the IBM PS2. I'm going to add to something to that continuum, and it will amaze you just as it did when I heard it. So I was in Riyadh a few days ago for the Disputes Week, and not surprisingly, there was another panel discussions similar to this. And one of the people in the room was Mr. Michael Black, who, as many of you might be knowing, sits as a judge in the DFC courts. And this is what he had to say. He was talking about a technology where a smart contract has 3 keys. And one of the 3 keys is with the court. So when for executing an award or a judgment, all the court has to do is side with one of the parties, and the contract is self-executed. And before any of you think that this is very futuristic, he told us that it had already been developed, it was under testing, and it was going to be launched soon. So my question to the panelists is, do you know of any other jurisdictions that have reached this level of sophistication or advancement? And for the Indian members of the judiciary on the panel, in our lifetime, will we ever see such things here in India? And a quick comment on what Mr. Predieri had to say about artificial intelligence as an arbitrator. Just in case you take party autonomy into account and two parties are willing to submit to an AI, you will also have to think about whether such an award is enforceable in another jurisdiction. And here, if you look at para 2 of Article 1 of the New York Convention, it says an arbitral award includes an award made by an arbitrator and an arbitral institution. And so if you give a very broad definition to the term institution to include AI, you might be able to do it. Thank you.
Mr. Wilmot Smith, will you take this?
Well, just answering your question about Michael's Brave New World, I'm not aware of anything like that. But then my state of knowledge of other jurisdictions is likely to be deficient. I think we're all a little bit parochial. I may have misunderstood, but I think what you're talking about is a world where there is a decision, what I call the hat-pin school of jurisprudence, that you have the hat-pin and you close your eyes, you twirl it around, and you've got a piece of paper with claimant on one side and respondent on the other, and then the hat-pin comes down on one or the other, and that's what is decided. We've had hat-pin judges for ages, a little bit like I call a pendulum judge, somebody who looks to the left and to the right, and the last person who he speaks to is the one that wins. I suspect that bit of AI is purely an extension of that and shouldn't be serious, because the hat-pin school of jurisprudence as that school of jurisprudence are the same, they're just unacceptable.
Mr. Predieri, will you, from a civil law perspective?
No, but I think that you raised a very important point, which is the recognition and the enforcement in another country. I mean, there might be even a jurisdiction where an award can be decided or taken by an AI, but the issue is whether you can enforce that award in a country. I mean, in Italy, there is one of the last limit for the enforcement is the public order. And as it stands today, even if there is a jurisdiction where you can, in which the decision can be taken by AI, if it applies to that jurisdiction, it's fine. But if it comes to Italy, that's the end of the road, because with the pieces of legislation I mentioned in the European Union, I suspect, never happened to, there is not a case yet, but I suspect that that could be an issue with the public orders. I know that, for instance, that there is in the United States a platform that I think is called CyberSettle, where it is completely automated. Fine, I mean, if that is used there, but I don't think that it will have any success in enforcing an award taken by that platform in Italy.
Thank you. Thank you, the audience first, and then all the panelists. I think for the further thinking, we'll need more time. So we close this session now.
Great. Thank you, sir. I would like to thank our chair and distinguished panelists for that very insightful session. I think all of us are taking a lot of food for thought. And as Mr. Subramanium has said, a healthy sense of discomfort as to what the future holds for us, and hoping that human intelligence does persevere. I now call upon Honorable Justice Rekhapalli to felicitate our distinguished chair and panelists with a small token of our respect.
Yes, you can. You are trained for that only. Thank you.
Thank you, ma'am. We now end the session and we'll have a small break and then we'll reconvene for the closing section. Thank you, everyone.
I think he's the best advocate I've seen. I didn't. Certainly no better.